Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at an excellent book from Sweet and Maxwell, part of Thomson REUTERS. This is an important book because it's looking now at the global world that we're facing. This is Cross-Border Insolvency, Principles and Practice. It's the first edition of this work. It's this book here. It's been written by Look Chan Ho. This is the book, blue cover at the front. There's the spine, nothing on the back. It's a hardback and it runs to something approaching about 330 odd pages, in fact. 350 pages. There's the index at the back, which is done on paragraph numbering, not on page numbering, which you can see, the index starting there. You can see you've got paragraph numbering at the sides and lots of footnotes. Lots and lots of wonderful footnotes throughout. There's the front page. The details of the author, and as you can see, it's an important book. There's a nice dedication, which I think is always worth mentioning because of who it's devoted to. There is the preface. The preface is always worth reading because you get some idea, especially with insolvency, of what is happening at the moment. Now, on page 2 and 3, that continues, and in fact, he said it's on Buddha's birthday, 2016. Now, I have to make a confession to you. I do not know the date of Buddha's birthday, but I'm recording this in the autumn of 2016, and it's clearly some while earlier in the year. So my profuse apologies, but I don't actually know the date itself. Table of contents, you can see quite detailed contents there by chapter number. You can see them running through like that as we go through. There are 7 chapters in total, and then there's the index at the back. You've got a table of cases. It's a very erudite work, this, by the way. The author has put a tremendous amount of effort into it, to which he should be congratulated, and I am. There we go. Table of statutes. Again there, and then you've got the statutory instruments. Then we go straight into the book here. And that sets out the jurisdiction right at the beginning with chapter 1. And as you can see, it's got the background, introduction background, and it's got some detail. Immediately you've got the actual paragraph numbering, a bit like the law reports, the paragraph numbering over there on the side, and you've then got the actual footnotes to back everything up. And he starts off by saying questions of cross-border insolvency must begin with the jurisdiction in which a firm may be subject to insolvency proceedings. Fundamental point. It's interesting in the year 2016 for me to say that, because I suspect in a few years' time we could be into a very different type of approach to what we're doing with a lot of things, apart from the obvious digitisation of everything. This is chapter 4 here. Again, you see it starts off with an introduction and you've got the meat of the subject, and then right at the back you do have a lot of referencing as well to justify all of the points that are actually being made throughout. As I say, it's a fine work, this one, without any doubt, and he has put a tremendous amount of effort in with all of the cross-referencing throughout. There we go. So if your practice is in dealing with cross-border insolvency, this is absolutely a must for you, and it's up to the very highest standards of Sweet and Maxwell. Well, Elizabeth and I have written a book review, which is on the web and in the journals. We've given our title for the review the following: Cross-Border Insolvency Scrutinised Through the Lens of Conflict of Laws. And that's exactly really what he's looking at, because we are looking at the differences between the various jurisdictions in how they approach insolvency. And of course, it's a very, very big issue, and in the global marketplace of much greater importance than hitherto. Anyway, this is what we say about the book. As in any other area of law, insolvency reveals a number of aspects which suggests, that there could be a bit of room for improvement here. It makes sense, therefore, that the room for improvement argument looms even larger and more mind-blowingly formidable when the insolvency practitioner is confronted with the complexities of English cross-border insolvency law, which is examined in this book with what we describe as scholarly punctiliousness and zest by Hong Kong-based author Look Chan Ho. who provides more than a few barbs of criticism along the way. And I should say quite rightly, two probably. This book, he says, grows directly out of years of observation as a practitioner that many aspects of English cross-border insolvency law are unsatisfactory, adding that the root cause is that the book looks at taxonomic order and the practice relies too much on improvisation. And it's tempting to remark here that generally English attitudes towards and the flair for improvisation have, for the most part, not been no bad thing. Within a tolerant climate, improvisers in law or in any other sphere of activity are actually allowed to run around loose, either to flourish or to find themselves consigned to outer darkness. But of course we digress when we talk about this. The author's stated aim is to guide and improve the practice of cross-border insolvency law through the lens of, that is, from the perspective of, conflict of laws. And that's really where the book fits within the legal structure, if you like, of where you'd be looking for a book in this particular subject area. Now, it's recently been published by Sweeten Maxwell, as I said, as a first edition, and the book examines cross-border insolvency law via three main topics. The first one are the questions of the court's jurisdiction where there exists a foreign element, always a problem, of course, in a modern era. Then there are the issues inherent in enforcing foreign insolvency proceedings, again important because enforcement is always something that is a very thorny issue, both in English law and elsewhere. And finally, there is the matter of the choice of law, although the focus of discussion is primarily of English law, because that is where the chosen legal jurisdiction for many a contract, and certainly that, of course, is what the author is putting forward. Now, it's English law which, as the author points out, offers the widest and most complex range of cross-border insolvency regimes in the world, and he further states in effect that no writer hitherto has attempted to rationalise the whole corpus of cross-border insolvency law before, and in this respect it can be claimed that the book is unique. Certainly the accompanying research is very extensive, and I was quite taken by how much work he'd obviously put in. A huge amount of effort has gone into the creation of this book. It's obviously targeted to insolvency law practitioners, and the book opens up an impressively broad spectrum of insight and opinion with which we think readers may or may not agree. And for example, it's the author's view that the UN Citral model law on cross-border insolvency is what he says, quote, a profoundly misguided document, and that the pari passu principle is often misunderstood. Well, I would agree with that, because I think a lot of people do have problems with that. Now, the book's organised in 7 chapters and features closely argued analysis of an incredibly wide variety of cross-border insolvency issues, problems and contingencies, with frequent reference being made to significant cases and judgments. And of course the aim the author has is being to assist the reader in achieving an enhanced understanding of insolvency policy and principles. Let me conclude by saying researchers in this area will appreciate the extensive footnoting and tables of cases, statutes and SIs which the book provides, and there's little doubt that specialist practitioners finding themselves embroiled in the almost Byzantine complexities of cross-border insolvency law will welcome this important addition to the literature of the topic. We will fully concur with that. The date of publication, as I say, is cited on Buddha's birthday, 2016, and I'm afraid my ignorance of the date is something I really must check up on Google very quickly indeed. I'd like to thank the author, though, very much indeed. Look, Chan Ho has done a very good job there. There's the book again. Let's open it up in the middle, and you can see paragraph numbering at the sides. It follows very much the standard structure. You've got some nice subheads, and you've got a lot of footnoting. A lot of detail has gone into this, which is what we expect from Sweeten Maxwell. I'm very grateful to Sweeten Maxwell, Thomson Reuters, for producing this work. It's a first-class work, as all their publications are, and we can't do our jobs basically without having this sort of work. And it's easy to get at. It actually saves us a lot of time. So thank you to everybody involved in this book. It's well worth getting if you're an insolvency practitioner, especially with the global world which is now upon us. Thank you. Bye-bye.